you everybody for signing in today. I'm Amanda Whitson with Coldwell Banker Property Management, and I will be facilitating and not really moderating because everybody has a presentation. But so our keynote speaker this morning mentioned several programs available to renters who are facing eviction since COVID. This session will expand on those programs and help tenants and landlords, and also discuss some of the new laws put into place in Virginia to protect tenants. If you have any questions for the panelists, please type them in the chat box. And after each presentation, we will address them. And today we have two speakers. Senda Gori is the Associate Director of Eviction Prevention with the Virginia Department of Housing and Community Development, and Barbara Marmet, the Staff Attorney at Blue Ridge Legal Services. And thank you, ladies, both for joining us. And so, Barbara, let's just let you take over the reins now.
All right, sounds great. Thank you for having us here. I do have a PowerPoint that I am going to share, and I'll go through it, and certainly if there are any questions, I'm happy to answer them. So, to actually start the presentation. There we go. All right, so I'm going to go over some of the relatively new protections. Most of these are specifically prompted by the pandemic. Some of them are temporary right now. We will see whether, which ones last. My general theme of what the protections are is that they provide tenants with additional time, additional resources, and additional payment options. So I'll start with nationwide protection that probably a lot of folks are familiar with. But the Centers for Disease Control and Prevention, the CDC, has a moratorium in effect on residential evictions. Currently, that order goes through the end of this month, March 31st, 2021. It has been in the news that the administration intends to extend the moratorium, but that has not officially taken place yet. So we will see what happens in the coming days. I do anticipate that it's going to be extended, but as of today, I haven't seen that yet. The moratorium does, it is a moratorium on the actual eviction. It does not relieve tenants of any obligation to pay what they owe under their tenancy. So for the rent or late fees or utilities or any other payments that are due. Also importantly, the moratorium does not prevent all evictions. There are 5 enumerated exceptions within the moratorium, largely for things like criminal activity, destruction of property, violating like building code. We are also seeing pretty consistently that, at least in our area, judges are not applying the moratorium to prevent evictions based on a termination of tenancy or termination of a month-to-month tenancy. That's something that advocates across the country have been litigating and advocating for the moratorium to apply to those, because I think it's not 100% clear in the language of the moratorium. But what I can say is that around here, our judges have not been applying the moratorium to prevent an eviction where it's because of a termination of tenancy, which has to some extent been a little bit frustrating, because a lot of those terminations ultimately are motivated by the fact that those tenants are behind on their rent and the landlords are tired of not getting paid. And if it's a month-to-month tenancy, then the landlords just have that option of terminating, and there's not. So those tenants are not getting the same protections as other tenants who are behind on rent. And there is a requirement in order to be protected by the CDC eviction moratorium. The tenant has to provide the landlord with a written declaration. And that declaration goes through what's on this slide, which that declaration is a declaration under penalty of perjury that says that the tenant is covered by the order. So the tenant has to swear to the the fact that they have been using their best efforts possible to obtain all government or other assistance for rent or housing, that they need an income qualification, which I won't read out loud, but that's that point too. You only qualify for the CDC moratorium protection if you're below a certain income threshold. The tenant has to affirm that they are unable to pay due to some kind of extraordinary circumstances. So it does not protect tenants who are in the situation that they were never able to pay. I mean, there has to be some kind of situation where they're experiencing a loss of income or additional expenses. The tenant has to verify that they are using the best efforts possible to pay what they can, and that eviction would render them homeless or force them to move into a shared living situation. The purpose of that CDC moratorium is to prevent or minimize the spread of COVID-19. So that's why you see that last piece, which is, it is quite clear that places that have had eviction moratoria have there's a direct correlation between allowing evictions and increased spread of COVID-19. So that's the justification behind this order, which is we need to not have folks who are going to be homeless or living in, crowded situations, because that's going to make the pandemic worse. Moving on to some of the state level protections. So in Virginia, there's been a code change, and then there's also a change that has not been codified that's in one of the budget bills. So that's the two references there. I just did that. Okay. The landlords cannot take any action to evict a tenant for non-payment of rent unless they follow certain new procedures. First of all, landlords must give a 14-day notice previously for non-payment of rent. What was required was a 5-day notice to the tenants that they must either pay their rent or their tenancy will be terminated. They now have 14 days to pay what is owed. Those notices also need to include information about the Virginia Rent Relief Program, how to reach the rent relief program, including 211 Virginia to get rental assistance. Both of those provisions are not permanent at this point. The requirement that the termination notices include the rent relief program information that's intended to last through the end of the state of emergency. So that's when that provision will sunset. The 14-day time period in that pay or quit notice right now, as the statute stands, is going to expire July 1st, 2021, but there's a bill currently just waiting for the governor's signature that would extend that to July of 2022. It just hasn't been signed yet, but from what I understand, it is expected to be signed by the governor. So that 14-day notice period should be extended at least through July 1st, 2022. Also required, and this is another provision that only lasts through the governor's state of emergency, in addition to advising tenants in that 14-day pay or quit notice about the existence of the rent relief program, the landlord actually has to advise tenants that they will apply for rent relief on the tenant's behalf unless the tenant tells them that the tenant is applying. If the tenant does tell the landlord that they are applying for the rent relief program, then the landlord doesn't have to apply. We don't want two applications out there. But if the tenant is applying, then the landlord also in that notice needs to explain that they will cooperate with the tenant's application for rent relief. Once that application has gone in, there is a provision that it doesn't go on endlessly. So if the tenant refuses to apply or refuses to cooperate with the landlord's application for rent relief, then the landlord can still proceed with an eviction for non-payment of rent. If the application takes too long to be approved, there's a 45-day window. And if that 45 days passes, the law provides that a landlord can proceed with eviction. The guidance that has been put out there is that 45 days starts from when a complete application has been submitted. So, which, it's not always obvious what the date of the application submission is, but so we anticipate that there will be some issues with that with some of our clients, but we'll see. Or if the application is denied because the tenant's ineligible for rent relief, then the landlord can proceed with eviction for non-payment of rent, or if the program has run out of funds. Another provision that is new, and this is another one that is currently set to go through July of this year, but we expect will go through July of 2022, is that larger landlords who own 5 or more properties, must offer tenants, again, in that notice, that notice to pay rent or quit. They must offer those tenants a repayment plan for the amount that's due. And that payment plan must allow the tenant to pay over 6 months or the remainder of the lease, whichever is a shorter period, the amount that is past due without late fees. So that can give tenants who have fallen behind for sort of unusual circumstances, but are kind of getting back on their feet, that can give them a little bit more time to get caught up. The tenant has to agree to the payment plan, and if the tenant defaults on that payment plan, then the landlord once again can resort to an eviction. But in that initial stage, the landlord cannot evict unless the tenant refuses to enter into the payment plan or misses a payment. Another option for tenants, just to get additional time. So one of the things I said at the beginning was that a lot of the provisions give tenants additional time out of recognition that folks are experiencing some kind of extraordinary circumstances, and the goal is to give folks some time to access the resources that might be out there to help them. So any tenant who has experienced a loss of income due to COVID-19, when they go to court for the first time, and this is a provision that needs to be invoked at the first time when the tenants show up to court, can ask for a 60-day continuance of their unlawful detainer if it's based on non-payment of rent. They do need to bring proof with them to court that they have experienced a loss of income. So this is something that I think would be helpful if the word can get out to more folks, because by the time we see them, we've been going to the first return dates for unlawful detainers in the Winchester Frederick General District Court. But by the time we see those folks there, they don't know that they need to bring proof with them to court to show that they've experienced a loss of income. But if they do bring that with them, if they can show, if they can bring in a pay stub that shows that they've had reduced earnings, or a copy of a notification letter that says they're being furloughed, or other documentation that shows that loss of income, and their unlawful detainer is based on non-payment of rent, they can ask for that 60-day continuance, which doesn't dismiss the case, but it does give them that additional 60 days before the case really ramps up to try and access whatever help might be out there to get them paid up on their rent. Another provision that is new is that landlords who own 5 or more, and this actually just took effect March 1st of this year, landlords who own 5 or more rental units or have a 10% or greater interest in 5 or more rental units cannot take any adverse action against an applicant for tenancy based solely on a bad payment history or eviction for non-payment of rent that occurred during this sort of pandemic emergency. So, notwithstanding the fact that there have been protections, obviously there are folks who are going to have a negative record reported in some way, either for non-payment of rent or bad payment history from their prior landlord. And if that took place starting March 1st, 2020, and going through the end of the state of emergency, larger landlords are prohibited by this section from basically refusing to rent to those folks because of that bad history. So that's just took effect at the beginning of March, and I believe that's supposed to go through 2027 or maybe 2028 or 7 years after the end of the the pandemic state of emergency in Virginia. So that should give some folks a little bit of protection for a little while, at least for folks who have had kind of an unusual setback during this pandemic. That gives them the opportunity to kind of not have that follow them and not have that cause them adverse consequences through the next few years. So I went through all of that fairly quickly, but if there are specific questions, I'd be happy to answer them.
We've got about 10 minutes left. So yeah, if anyone has any questions for Barbara, you can either throw it in the chat box, or you could also just raise your hand and unmute yourself and ask.
It looks like I got one question. Cases where the tenant is not behind on any rent and is staying as a holdover tenant after the end of a lease, and the tenant is not violating the lease. I'm guessing this is a question about the applicability of the CDC eviction moratorium. And what I will say is that if the tenant is not behind on any rent, so there's no rent that's being sued for in the unlawful detainer, and it's a holdover situation, what we have been seeing is that the judges in our area will allow that eviction to go forward.
We also had someone ask Barbara if you would be able to provide the PowerPoint.
Sure.
If you can send it to one of us on the Housing Coalition, and I think we can probably send it out to all the attendees today.
Absolutely. Yeah, I'd be happy to.
Any other questions for Barbara? I have a question for you. With the last slide where you were talking about the previous evictions not counting or not being able to take in consideration, or not being the reason an application is denied, that is only evictions that occurred during COVID or as a result of COVID, or is that okay?
Yep. Yeah, so it is evictions that have occurred during the period beginning March 12th, 2020 and extending through the end of the state of emergency.
And does the tenant need to provide any sort of documentation to the potential landlord showing that that was a COVID-related eviction scenario, or is it just if it happened during that time frame?
So I don't know exactly the answer to that. This is a new provision, and I think it's a little bit similar in terms of the other protections that are out there on reasons that a landlord can or cannot refuse to rent to a tenant. So I think, I guess I'll say what might be helpful for a tenant is if they can explain up front, you may see this on my record, this is because of a non-payment during COVID. That probably would be more beneficial for them than waiting to see whether the landlord takes adverse action against them, denies their rental application, and then go back and say, hey, well, but that was because of COVID. But it is a little, it's not always easy to tell why a landlord does deny an application. So there's a practical problem, which is that this is a protection that applies to adverse action against an applicant based solely on that eviction during COVID or that bad payment history during COVID. And someone says they can put the 100-word statement on their credit report as explanation up front. might ask Karen to explain that, but it protects if it's solely based on that, but there could be other factors
Certainly.
that, they're not necessarily protected just because that was one of the negative things that came up.
Sure. And next we have a question from Andre Miller. What is the current wait time for a referral?
I'm guessing that's for the rent relief program.
I'm not sure. Andre, do you want to unmute yourself and further explain your question a little bit so Barbara can answer?
No mic. Okay.
Okay.
The main
So I'm sorry. I can't figure out how to raise my hand, but I can explain the 100-word statement. So everybody has the opportunity to put a 100-word statement on their credit report for the 3 credit bureaus. So if they would want to proactively go ahead and write that statement explaining the situation with COVID and put it on there, then the creditors would see that up front.
Gotcha. Thank you.
And so, yeah, Andre said referral in reference to assistance with the RMRP.
CENTA is probably in a better position to answer that. There's no referral per se with the RRP, so either tenants or landlords can initiate an application, but a lot of people are applying for assistance from the RRP, so there is a timeline for having the application reviewed and responded to. And I think that timeline has varied some over time. So.
Can I chip in, Barb?
Yeah, go for it, Elaine.
We've seen a varying range, but the law says that they've got up to 45 days from the date of application. And we're seeing that some people are not getting their money until that 45 days is almost run out or has run out. So it's taken a while to get through the process. And sometimes it's difficult to get through get the applicants through the portal. We end up helping people with it. It tends to be quicker when the landlord applies, but I've seen applications that are taken way longer than a month to get through, and that's just my personal observation. Again, CENTA's going to be the one that's going to be able to give us the most definitive answer, but I wanted to give some real life practical thoughts.
Well, I think then we will use this as a nice time to transition to CENTA's presentation. Barbara, thank you so much. And again, if anybody has any questions, Barbara, I believe, will be on the rest of this session anyway, so we can always go back to her for those. So CENTA, at this point, I will let you take over. And I think we were having some issues with you being able to share your presentation. Are you able to do that now?
I think so. I don't know that I was the one having, it says host disabled participant screen sharing.
Oh, yes. So in order to do that, you would have to leave the room really quick to go back, and then Dave reassigns you.
Okay.
If you want to do that really quick, maybe then we have another question for Barbara.
Okay, I'm going to leave the room and then send a chat to Dave.
Yeah, well, you'll leave the room and go to the main room, and then there Dave will be able to reassign you, and then you'll come back in. Sorry for the confusion.
Always some sort of technical glitch with all of this virtual meeting stuff.
Absolutely.
And I will say, Andre, you had mentioned the timeline on the RMRP program. I personally have gone through this with several of my tenants, and our turnaround time has been pretty good, within a few weeks to a month in most situations. I think it seems to vary greatly based on the area that you're and who's servicing it and how overwhelmed they might be with applications.
Yeah, and it is for us sometimes difficult to tell when everything actually got submitted, some of our tenants think that they've started the application, but they haven't submitted everything that they have to submit. So there is definitely a little bit of a learning curve in figuring out how to get through the application and make sure that everything is there that needs to be there.
Well, and sometimes we're having trouble with landlords that say they've done the application and they haven't. Don't know why, whether they're purposely not doing it or just having technical difficulties. So I think a lot of it is just not knowing all the data points.
Mm-hmm. And the portals can be a little bit difficult to navigate depending on technological comfort. They're very online portals, and I have seen both landlords and tenants struggle with understanding how to navigate it all. And I think the folks who are running it are doing the best that they can to provide, step-by-step guidance on what to do. But it's not, it doesn't come easily to some folks. And it looks like Andre says most of the veteran tenants that they work with are experiencing delays or in the Nova area. So,
all right, we've got Cinta back. Okay, so Cinta, again, I'll let you take over from here.
Okay, can you hear me?
Yes.
Great. Ooh, a big gust of wind just slammed a door. And can you see my slides?
Yep.
And is it just one slide that you see?
Correct.
All right. Okay. I have officially gotten over all of my technological challenges. Thank you very much for having me here today. My name is Senta Gori. I'm the Associate Director of Eviction Prevention at DHCD, and I direct the Rent Relief Program, which is, of course, what I'm here to talk about today. Sorry, maybe I spoke too soon. Okay. Okay. So I'm just gonna go over some basics of the program first. The Rent Relief Program is an emergency response to the pandemic, and the funding requires that folks have experienced a negative financial impact that can be either direct or indirect because of the pandemic. We have 2 doors of entry. One program, 2 doors. I think that is not always perfectly understood. The landlord door and the tenant door, both of these are DHCD RRP programs, with the landlord door being administered by Virginia Housing and the tenant door being administered by a statewide RRP support center. The same information is required of both parties, regardless of which place the application is initiated. So that's important to know. At the moment, the landlord side is moving faster than the tenant side. At this point, that's almost entirely because of the volume that the tenant side receives, which is greater than the volume on the landlord side. But we are beginning to see the 2 sides. We still have a little ways to go, but we are beginning to see the 2 sides kind of have more parity in the length of time it can take to process an application. Our program is available statewide. There's 2 exceptions to that, and I know that neither of these localities are in this audience's immediate community, but important to know that both Chesterfield and Fairfax counties are drawing down their own emergency rental assistance dollars, as they are allowed to do from Treasury. That is a rule by Treasury that localities with 200,000 people or more had the right to do that. Virginia has 10 such localities, and 8 of them allowed for DHCD to administer their dollars for the sake of continuity across the state. So unless you're in one of those 2 counties, your experience should be the same, regardless of what part of Virginia you live in. So there's 3 basic eligibility requirements for the program. The first is that a household's income does not exceed 80% of AMI. We are only looking at the current month's gross income. Applicants will not be required to provide income documentation prior to that. The other basic eligibility is that someone's rent cannot exceed 150% of fair market rent. And then finally, as I mentioned at the top, folks do need to demonstrate a COVID-related impact to their finances. And I'm just going to want to say a few things about this. One is that this is a self-certification. So that is one way that we attempt to reduce the barriers to this program. And I also want to say that this does not need to be limited to someone having lost their job or had experienced a reduction in hours. This can also apply to folks who have increased expenses that can be tied to the pandemic. And the example I often give is, if you might imagine a mother who has to work outside of the home, and her child is attending school inside of the home. She finds herself now paying for childcare that she didn't have before. That qualifies. If someone lost work earlier in the pandemic and is now employed again, as long as their gross earnings fall within the eligibility requirements, we would take the fact that they did experience a period of unemployment and still need to get back on their feet. The point is that we try to cast as wide of a net as possible with this piece. And I'm spending so much time on it because it's my experience or observation that while we have designed this for this to be a very an eligibility requirement with a wide scope where we try to screen as many people in as possible, we're not accustomed to that in the housing world. And I find many providers unintentionally are screening people out because they are not accustomed to such a flexible eligibility requirement. So if there's any questions about that, I'm happy to answer them. Again, it's one program with 2 doors, and here are the access points for both of those. I will send this slide deck to Jennifer, or whoever Jennifer tells me to send it to, and she will share it. It will be shared with all of you, so don't feel the need to scramble and write all of that down. I want to make clear what is required for applicants, and again, this is required regardless of which door someone walks through. The first is a rental agreement. In many cases, that is a traditional lease, which is great. But we have designed this to also accommodate for folks without traditional leases. So for those folks, there are 4 minimum requirements that need to be in this alternative lease documentation. And these are according to Virginia state law. So it has to include the tenant and landlord's full names. It needs to reflect the monthly rent amount and anything that's included in that rent. So if utilities, internet, late fees, anything that's included in the lease, we can pay 100% of, but we do need to see it reflected in that formal or informal agreement between the landlord and the tenant. And then we also need to see, when did this agreement begin and when will it end? And as I said, if that's not available in a traditional formal format, if the tenant and the landlord can agree to document that with those 4 items, we will accept that as a rental agreement. We also need to see a ledger. And again, so for traditional landlord-tenant relationships, that's going to be there. in more informal settings, that ledger may not exist yet, but we will need to see one developed that reflects any back due rent if someone is requesting that, or the current and future months reflected in a ledger. And we, of course, need to see income documentation from folks to ensure that only people at or below 80% of area median income are receiving this assistance. This has been an element that I have personally found confusing. When I see the list of income documentation options reflected, I think it would be easy for someone, particularly someone who's under a great deal of stress, to see that and think that they need to provide all of the things on that list. So what I want to make clear here is that a tenant only needs to document their income once. So if you have if the tenant has a pay stub, great, that's all we need. If they don't have that and instead can provide a copy of a bank statement, that's fine, or a letter from an employer, that's fine. We also have self-certification forms for folks who have zero income, or for folks who are paid in cash and want to be able to honestly reflect that they have income but are unbanked. So we allow for a self-certification in those circumstances. One other note about income documentation is that for households of 3 people or fewer who are receiving TANF, WIC, SNAP, or LIHEAP, all of those families have already been proven to be at or below 80% of area median income, no matter where they live in the state of Virginia. So we would, those families would only need to provide documentation of their participation in one of those programs and would not need to provide further income documentation. But my point here is that someone only needs to document their income one time, one way. And I want to make sure that folks aren't getting overwhelmed by the long list of possible ways that someone could document their income. Almost done with this slide, but the landlords Virginia W-9 is a requirement. I know that this can be challenging for some, but a W-9 is a Treasury requirement, not a DHCD requirement. It's not something that we can be flexible around. And perhaps the greatest point of confusion is that we need to have the Virginia W-9, not the IRS W-9, because it's the Commonwealth of Virginia that's cutting the check. But both of those forms are linked on the website for both the tenant and, not both of those forms. The Virginia W-9 form is linked in both places, the tenant and landlord sites. And then finally, we have an RRP landlord-tenant agreement, and that outlines on the tenant side, they're attesting to the fact that the information they've provided is true and accurate. On the landlord side, they're attesting to the fact that they won't evict due to non-payment of rent for any of the months for which we have provided assistance, that they are not receiving duplicate payments from any other source, and if they do, that they need to return those funds to DHCD. And both parties are now attesting to the fact that the other party can receive information about the status of an application. We know that the tenants have struggled with the fact that they have needed to rely on their landlord in order to provide them with information about whether an application was submitted or what the status of it is or how much money was received. So now tenants are able to contact Virginia Housing and learn that information on their own. And that's in response to the feedback we've received from community, which is always helpful. Some important things to know about the program. I don't think all of these things are widely understood. We can pay for 100% of arrears beginning April 1st of 2020. However, and this is the part that seems to be new to a lot of folks. Tenants do not need to be in arrears in order to be eligible for rent relief. You just need to meet that income qualification, that fair market rent qualification, and attest to a negative impact on your finances because of COVID-19. But that means that even if you're up to date on your rent, we can start paying 100% of it now, and we can pay 3 months into the future. Sorry, meowing kitty cat. We can pay 100% of rent for 3 months as long as that lease agreement, and that's one of the reasons why we need to see the date that it begins and ends. If the lease agreement extends 3 months into the future or up to 3 months into the future, we can pay up to 3 months of future rent. I'm saying up to because if someone's lease agreement extends 2 months, we can pay 2 months. 1 month, we can pay 1 month. If someone is in a month-to-month situation or has a lease that has expired, but they're still living there, we will accept a lease amendment. And that just needs to include the same information, who's this agreement between, how long will it last, what does it cover? And then we can pay 3 months into the future for everyone who provides that. The exception to paying 3 months into the future is for folks with a housing subsidy. So a couple of things to know. Most importantly, people who are accessing housing assistance are eligible for rent relief. However, they're only eligible for their portion of the current month and their portion of their arrears dating back to April 1st, 2020. We're not able, and this is Treasury guidance, we're not able to pay 3 months into the future for folks with a subsidy, because really what should be happening is that their income is getting recertified and their rent adjusted accordingly. And so therefore, the other requirement placed on folks with a housing subsidy is that they need to have their income recertified with their housing provider before they can be eligible for our assistance. But if they do that, we can pay the 100% of their arrears and 100% of their current month's portion. Quick update on how we're doing with the rent relief program so far. We've officially prevented more than 25,000 evictions across the Commonwealth. We've distributed almost $111 million so far, and we're beginning to see the average amount of rent relief payments ticking up. This is in part due to how long people have struggled to pay their rent. It's also due to the fact that we can pay those 3 months forward. So the amount going out per household is ticking up. And this information is as of March 10th. So in reality, these numbers are already higher. We're really starting to see the systems that we've been building for months now come into play. And that's reflected in our numbers. I just learned this week that Virginia is one of only 2 states in the country that have actually begun to spend our emergency rental assistance dollars, which makes us feel great about what we're offering to Virginians, but should give all of us pause if the moratorium is not extended and ERA dollars are not flowing. And of that 111 million or so, about 52 million of it is the ERA money, which came in January. That's also a reflection of the exponential growth and effectiveness of the program, because it took us, 6 months to spend that much, when the program first launched. And then we were able to spend the same amount in a period of just over 2 months. So we know that unless these dollars are flowing to the people who need it most, the impact we want to see won't be there. I need to update the 20,000 on this slide, but what you can see here is that over 73% of the households who have been served are at or below 30% of area median income. So we're really reaching the people who need this assistance most. Close to 17% are somewhere between that 31% and 50% of AMI, with less than 10% being anywhere near the threshold of 80% AMI. So that's something we're proud of. It's a great start. And this data here is statewide. We know that Black and Brown communities are at the highest risk of experiencing eviction. So we're proud of the fact that statewide, more than half of the households we've served are Black households, with a little less than a third being white households, and then the remainder being made up of other races. This was hot off the press, so I didn't have time to develop a slide for the counties served by the United Way, but I do have the data, and I can share it with you now and include it in the email when I send the slide deck. So for the localities in the United Way of Northern Shenandoah Valley's service area, we have paid rent for 447 unique households, and we've made 509 payments. So we do see some households who have been able to return for additional assistance. All of those payments amount to over $1.8 million. And as we talk about race and ethnicity, as I mentioned, these are statewide numbers. On a local level, they are even more reflective of community. So for example, when you look at the Richmond data, almost all of it has gone to Black families, which is reflective of the target population in Richmond. For all of your communities, about 68% of the households we've served are white households, 12% are Black, and 8.5 are Hispanic or part of the Latinx community. Here's some helpful links. We've got FAQs for tenants and landlords. And then this third link is a really important step for people who do have access to the internet. That's where people can do a self-assessment and see if they meet that those basic eligibility requirements, and then they're routed to where they should go to begin their application. On the landlord side, and really I think at least the Virginia W-9 piece of it applies to both sides. But the biggest issues are folks not actually sending complete applications. And on the tenant side, we're not able to send rent checks electronically. They're paper checks that are cut and put in the mail. On the landlord side, they are able to do that if a landlord requests it, and that both ACH forms are often a sticking point. It's important to know the reason for the focus on the landlord's side on these two particular slides is just that it is where we have been trying to route people until we see the backlog reduced more significantly on the tenant side. But a benefit to landlords of using the Virginia housing side is that if they have multiple properties or multiple tenants who need assistance, they're able to set up their account that way and then only need to provide, their portion of the application once. So there's a good scalability on that side. And important for all community members to know that, remember, this applies to folks who are receiving housing assistance. So a public housing authority as a landlord can go into the Virginia housing side and set up their account to cover any tenant in their property who needs this assistance.
Hey, Cinta, I'm just going to throw out real quick. We just got the 5-minute warning from Dave. So
okay, thank you. That's contact information. And anytime for questions.
So it looks like we had one come in that says, how do tenants submit necessary documents when they initiate an application over the phone?
So one thing I didn't get a chance to mention in the slide deck, this is going to answer that indirectly at first and then directly later. Another change that went live this week is that we now have a third-party authorization. So if a tenant has barriers to navigating our application process because of language barriers or internet accessibility or for any reason at all, they can identify a trusted third party, and that can either be it could be a legal aid attorney that they're working with. It could be a neighbor, someone at church, or just a nonprofit that they receive other services from or that they have connected with. And that trusted third party can not only complete the application for the tenant, but they can also receive future communications about the status of the application or any other troubleshooting that's necessary. And that's, again, in response to community, one of the steps that we're taking to just reduce barriers. And then next week, DHCD will be releasing a grant opportunity with significant dollars, millions of dollars to deploy statewide to pay organizations to provide culturally specific outreach and engagement or economic specific targeted outreach and engagement. And then we'll also pay those organizations to submit completed applications on behalf of the tenants, which will help with that backlog. The hardest part, and in response to that question about 45 days, the hardest part is us getting all of the information in a complete way. And we interpret that law that to mean that shot clock, as we call it, doesn't start ticking until we've actually received all of the required documentation. I am not aware of anyone who has submitted a complete application with all information from both parties and experienced a wait time anywhere close to 45 days. If you are working with someone who has, please let me know. But once we have all of that information, the QC and the cutting of the check is kind of the easy part, and moves fairly quickly after that. But being able to pay providers with existing trusting relationships with the communities who need it most to submit those complete applications will reduce the amount of back and forth required in order to get an application to the finish line, and ultimately reduces the overall wait time and backlog for tenants all over the state.
Is there a process in which, so you noted that you can have kind of like a designated representative. If someone has started the process themselves and has kind of found out that I'm not really technologically or for whatever reason able to do this on my own, is there a way to, after the fact, add someone as a representative?
Yep, absolutely. That third party piece is a form that they can complete online on both sides, regardless of where someone is in the process.
Anyone else have any questions for Senta or for Barbara?
So I have one real quick for Senta. So are you saying that because I have a landlord that's been trying to get through the landlord portal and is having a difficult time doing it. So is there an option for like our organization to help him get through that portal?
Yep. Yes, that applies to both the landlord and the tenant side.
Okay, and that form can be found on both of the applications.
Yeah. Okay. Yes, I was told it was going live this week and it's Friday at noon. So if you don't see that by Monday morning, let me know. I didn't check it. I haven't checked the websites today, but I believe
Okay.
they're.
Great, thanks.
Mm-hmm.
So I've got one more quick question if we don't get cut off. The income documentation for the current month. So let's say they started the application in February and, didn't actually submit adequate documentation. The income documentation, would that still be for February because that was the month that they submitted it, or for March because that's now when they're submitting their documentation?
The February, I think either one is the answer. Yeah.
Perfect.
Anyone else?
I'll take my 1 second here to just extend the highest praise possible for legal aid attorneys here and everywhere. You are all superheroes in my book, and we could not be doing this work without you all, or with all of the other providers all across the state. This has been a tremendous lift. We know it's not a perfect system, but we're also deployed more of these dollars than anywhere in the country, and we know that that's made possible from the input you've all provided to us. And please continue to provide that. And yeah, I can see where I'm getting the hook on the stage, but I want to thank you all for the roles each of you have played in getting us this far.
Thank you, ladies, for joining us, and thank you everyone else for joining in and listening to this information.